this session, and we'll take each one in turn for 20 minutes each, followed by a 10-minute response from Robert Werth, who will comment, and then I will invite the speakers to respond to those comments before opening up to questions from the audience. So first, in our presentations today, we've got Khandaker F Rahman and Nousheen Ritu from the University of Dhaka. So I will pass over to you and look forward to hearing the presentation.
Thank you. Okay, so allow me to share the screen. Okay. I would like to start off by thanking the organizers and everyone who's associated with this workshop for taking such a wonderful initiative and extending the invitation to us. I'm Nousheen Ritu, and I'm extremely glad to be presenting this paper today alongside my teacher and co-author, Khandaker F Rahman. So the topic of our presentation is revisiting the colonial legacy of penal practices in Bangladesh through the prism of cultural political economy of punishment. So the purpose of the workshop, I believe, has been to bring forward the realities and social experience of the peripheral countries in the field of punishment. And I think it's a crucially relevant issue because most of the mainstream socio-political or cultural theories of punishment that we have are more or less shaped and dominated by the narratives that are created by the developed countries. And I think it is here that we need to recognize that usually a lot of the peripheral countries have a unique history of colonialism and its legacy, which needs to be which needs to be recognized. And unless we recognize the impact and continuity of these legacies, we won't be able to develop an eclectic understanding of the complex penal trends and practices in these countries. So with that in mind, we are trying to explore some of the penal practices that have been perpetuated in the peripheral country like Bangladesh, and long after their colonizers have left. So briefly speaking about the objectives of our study, first and foremost, we have adopted a cultural political economic approach to recognize and assess the underlying motives behind the dominant form of penal practices. Next, we're trying to understand how these penal practices have been perpetuated and have impacted the existing penal practices in a country like Bangladesh. And finally, we're questioning as to why these penal practices, despite being so imperialist and repressive in nature, have been perpetuated in a post-colonial democracy like Bangladesh. So at the very beginning, I would like to start off by shedding some perspective into the concept of a political economic approach of punishment. So we know that the political economic theory of punishment is basically grounded in the critical theory approach that focuses on the dialectical structural relationship between the economy and the penal field. And the political economic theory of punishment basically claims that crime control policies or the modes of punishment are tools of power and control for the status quo through which they sustain the unequal power relations of the society. So one of the earliest political economic perspectives of punishment was put forward by Michel Foucault in his book Discipline and Punish, where he claimed that the brutal Middle Ages punishment were not aimed at crime control. Rather, they were a form of demonstration of power for the monarch. And this line of thought was reflected in the works of other scholars like Roos and Kosheimer, who have offered interesting insight into the emergence of prison as an institution. So they have claimed that the development of prison was not a humanitarian alternative, as many would claim. Rather, it was a way of capitalizing the prisoners as laborers in the face of rising demand for labor in the 17th century. So even though the political economic theory is an extremely relevant and extensive theory, it has often been criticized for its economic determinism. It has also been criticized on the grounds that it does not take into consideration the cultural dimensions of punishment. So for that reason, we have tried to incorporate the cultural element within the political economic approach. So the cultural dimension of punishment, I believe, can be particularly more relevant and useful when we're studying colonial penal practices, because the cultural analysis of punishment helps us understand why penal practices vary across countries and cultures and contexts. And it can also help us understand why brutality was a common element in almost all forms of colonial penal practices. So David Garland is someone who has done a lot of work in this field, and he has discussed how the nature, how the changing cultural factors like evolution of family structures, social ecology, and mass media have impacted the modality of punishment. So he has contextualized this in the changing punishment practices in the US and the UK during the 1970s, where punishment was becoming increasingly adaptive instead of being punitive or retributive. So this is said to have accounted to changes like the privatization of criminal justice departments, community policing programs, victim support programs, etc. So when we bring this cultural analysis of punishment in the context of colonial countries, we will have noticed that the colonial rulers have consistently and systematically labeled the social practices of those native countries as savages in order to impose their brutal penal practices in the name of civilizing this population. And what has happened eventually is that these countries have grown to believe that undergoing through brutal penal practices is the only and most effective way of eradicating crimes from the society. So for that reason, we are using an integrated cultural, political, economic approach to understand the legacy of cultural and political practices of the colonial powers, to understand how the colonial powers have exploited the institution of punishment as a form of a coercive network to repress the native population. And I think this framework can also help us understand why the same institutions and practices have been inherited and perpetuated by the post-colonial democracies for their own political and economic incentives. So in the following part of the presentation, Farzana ma'am will discuss more in details on what are the exact colonial legacy of penal practices in Bangladesh, and what are the underlying motives behind the continuity of these practices in a post-colonial country like Bangladesh. Thank you. I would like to invite Farzana ma'am to continue the presentation.
Thank you, Ritu. Yes, thank you. Thank you, Honorable Chair, and thank you, Ritu, for starting the presentation. Well, as Ritu has described, in India, the 18th century East India Company,
Farzana, I think you're having some issues with the internet. Could you start over, please?
Hello, can you hear me?
Yes, we can. Please start over.
The connection seems to be a little shaky.
Sorry, I have disconnected. Well, as Ritu has, okay. So, should I continue? Am I audible? Hello.
Yes, you're audible now, ma'am. Please continue.
Okay. So, like during the early years of British rule in India, there were brutal modes of punishment like mutilation and whipping, and those were abolished by the mode of imprisonment in 1894. And even though, like on several occasions, initiatives were taken in reforming the prison system in Bangladesh, but the colonial prisons remained largely violent, whereby more than disciplining and monitoring the prisoners, and the authorities were more concerned with capitalizing them as labor supplies. The prison system in the late 18th and early 19th century in Britain served as a tool for revenue extraction in the name of maintenance of law and order, and this was the same way. This is how the Bangladesh has also applying these forces as a tool of revenue collection and labor. So in the next slide, you can see that in Bangladesh, the overcrowding is one of the issues that are popping up. Prison conditions in Bangladesh remain to be deplorable due to overcrowding, inadequate facilities, and lack of hygiene. And the prison administration doesn't only struggle in ensuring the basic needs and conditions for the inmates, but also suffer from poor infrastructure management and operational environment. You can see from the statistics that Narangan jail held 2,023 inmates, while it had the capacity of 200. Similarly, Mani inmates against its capacity of 100. So jail officials shared that this extent of overcrowding creates the susceptibility of infectious diseases and heat stroke, as more than 2,600 inmates were already suffering from respiratory diseases and complications. So despite these discrepancies and different diseases in the prisons, the doctor to prisoner-patient ratio in the country is very poor, as reports find that the Dhaka jail had only 2 doctors for the 172-bed hospital, providing treatment to almost 400 people daily. So here again, you see that one of the reasons behind the overcrowding is due to the backlog of cases and detainees awaiting trial. Bangladesh has been identified as one of the top 3 countries in the world to have the highest proportion of detainees, pretrial detainees in prison, as revealed by a report of World Prison Brief. And the report shows that there are approximately 71,000 people in pre-trial and remand imprisonment in Bangladesh, which comprise 81.3% of the total population, prison population. So here I would like to connect the idea of cultural, political ideas, perspective of imprisonment to the current situation. You see that the subjective approach towards the criminality, in addition to their lack of trust on the efficacy of law enforcement or criminal justice system, shape the country's approach towards penal policies and practices. The colonial legacy of this form of brutal penal practices have been perpetuated in independent Bangladesh as well. What actually Ritu said, violence among the inmates in widely pervasive in the prison of Bangladesh due to the lack of monitoring and management by the authorities. However, the reported incidents are just the tip of the iceberg, given the true scenario remains to be concealed due to the official confidentiality and privacy. There are different instances we found in the media of torture and custodial violence existing within the prisons in the hand of law enforcement agencies and prison staff that go without investigation. A report by a prominent human rights organization, Adhikar, that finds that 4,000 people have been victims of extrajudicial and custodial death in the last 20 years in Bangladesh. And in just 2020, the number of death counts of extrajudicial and custodial death has been 207, as found by another similar report. So these evidences of torture inflicted upon the pre-trial detainees is not only a violation of law or human rights, but also a main manifestation of the prevalent impunity and lack of accountability among the law enforcement and criminal justice agencies. Although there are existing legal provisions like the Torture and Custodial Death Prohibition Act 2013 and the Prisons Act 1894, but the cases are often filed under these acts and their execution is extremely ineffective. So the law that Torture and Custodial Death Prohibition Act 2013, there has been only one case decided under this act till now. So you can see that the brutality of penal practices are perpetuated in the country through a vicious intergenerational cycle of political culture, power, and impunity. here there is another statistics by the prominent NGO Odhikar that 4,000 people have been victim of extrajudicial and custodial death, what I already said, and in the last year 207 people have been subject of custodial death. So here we can see that the law which are existing, or the prison has mainly used as a form to criminalize political dissident in Bangladesh. So you see that the colonial powers were used to thwart political action to dissidents through mass detentions, most of which cases never faced trial and conviction in the court of law, given the British rule's objective of perpetuating repression and control over the country. There were 49 articles in the Penal Code on crimes relating to the dissent against the state in order to suppress political dissidents. Similarly, you can see in the Penal Code, section 122 and 123, these laid down the offenses of sedition, which were routinely used to criminalize and tyrannize the freedom fighters. In Bangladesh, it is also seen that these laws were not only preserved and practiced. However, new similar laws have been made with similar hegemonic objectives. For example, we had a law in 2006 that the ICT Act, so-called ICT Act, and that act was replaced by another law, the Digital Securities Act, and both the act contained a provision which actually indicates that if anyone is intentionally posting false, provocative, indecent, or sensitive information on websites or any electronic platforms that is defamatory and can disrupt the country's law and order situation or hurt religious sentiments, can be penalized. So you can see there has been a law like the Penal Code, which contains the similar provision, but still the government has promulgated special law for treating or for penalizing the opposition people or opposition followers under this new law, the Digital Securities Act 2018. So under this Act, 2018 Act, you can see that the report finds that 457 people were persecuted and arrested in 198 cases, and you can see that the plaintiff who actually filed the cases, among them 33 of them were from the ruling party members, parliamentarians, Upajala Porishad chairmen, or mayor. So you can see they are the people within the structure, within the power structure. So here in the last slide, recognizing cultural political incentives underlying the penal practices. Here you can see that the trajectory of penal practices in Bangladesh, starting from the British colonial rules, shows how the modality of punishment and their underlying objectives have remained constant and unchanged. Imprisonment was decided to the primary mode of punishment during the British era, and it continues to be the primary form of deterrence in the country till this date. The brutality and the lack of regard for basic human facilities or hygiene grew as a cultural norm that is perpetuated within the current prisons in Bangladesh as well. So the purpose of prison in Bangladesh is not used to deter the crime or to reform or rehabilitation, but they would claim rather it is used as a repressive and punitive institution to secure control over the political oppositions or followers. So the political economic approach to punishment has for long dominated the understanding of penal practices as an apparatus through which people of power further their political and economic interests. Bangladesh continues to work upon these inherited penal practices as those in power continue to exploit penal institutions as a tool for political power and subjugation of the mass. The high pretrial detention rates testament to that. So despite these issues, this government recently has shown commitment to improving the situation in prison and to consider the overall reform of the criminal justice system. So very recently, the Ministry of Home Affairs and the Prison Directorate are working with the support of the GIJ's projects, we can approach to prevent corruption in the prison in Bangladesh. So talking about the way forward, I think we don't have much academic works upon these examples or upon the evidences we have been discussing in the presentation. So I think against this background, this paper shall pave the path forward in investigating and scrutinizing the penal practices to identify their underlying cultural, political, and economic motivations attached to the political repressive penal practices. So that's all. Thank you for listening to us.
Thank you so much. Really interesting presentation, and look forward to hearing comments and questions that we'll hold till the very end. Okay, so now I will pass on to the next group of presenters. So we have Kamil Mamak, Daniel Kwiatkowski, and Joanna Dudek from Jagiellonian University. So I'll pass over to you and look forward to hearing from you.
Thank you very much. I will be presenting our presentation, but Joanna and Daniel are among participants, and they will take part in the discussion after presentations. So I will share my screen. I think that everything is okay. So at the beginning, I would like to thank you, Luis and Maximo, and all others engaged in preparing that event. I will be talking about the paper that we prepared, and this is about some kind of paradoxical situation in which we have in Poland a situation that the legislators decrease the possibility, tighten the possibility of using probational instruments, and in fact, the system as such, the system as a whole was become less severe. So I will explain why and show on the data that we collected in the filed research. So after introductory remarks, I will talk a little bit about the probation. After that, I will present Polish legal context, and then I will present research and the result, and I will finish with the discussion of our results. So why such situation, which is in the title, it could be considered as paradoxical? Because if we will look at what is the purpose of the probation in theoretical point of view, we could say that it is a tool to decrease the severity of legal system. So the people who were supposed to go to the jail because there is a possibility of suspense of punishment, for example, they could be among us. They don't have to go to the jail. So this is one of the reasons that is pointed out. It is crucial from the perspective of probation that it allows people who are sentenced to remain in the community, and maybe they will not commit a crime and will not have to go to the jail. So people, scholars are treating probation as kind of alternative to incarceration. So if there is, in theory, if there is more probational instruments, there is less incarcerations among society. But the probation is not flawless. So there is a lot of research showing that in practice there is a lot of problems with probations. So some of scholars are saying that the probation can lead to over-criminalization. So this was the case in Poland. So it could increase the punishment for lower level crimes. So it was also the case in Poland. So basically, it's because offenders violate the rules during probations, and it is the way that they are ending up in the jail. So because of that, some scholars are calling the probation as delayed channel into prisons. So I think it was in US, almost a quarter of state prisons admissions in 2017 were for probation violations. So this statistic in Poland was even higher. So in recent, I will talk a little bit about situation in Poland. So in recent years, we have significant crime rate drop in Poland. So there is a huge crime rate drop in many of the most serious crimes. But the level of people who are incarcerated remain at the high level. So it was a kind of weird situation, and scholars and politicians are trying to find out why is the reason of that. When we were looking at the statistics shows that maybe there is a problem with probation. And in 2015, there was a huge reform of the criminal law, which was focused on that probations. People, the legislators, hope that if we tighten the possibility of using probations, the judges will be more lenient in their judgments. So the legislators were hoping that if there would be no possibility, for example, to suspend punishment of deprivation of liberty, the judges will not be imposing deprivation of liberty without suspension, but they will use other punishment, like, for example, fine or some limitation of liberty, which is in Poland kind of social service. In Anglo-Saxon literature, it's called that way. So we could see in the justification of the reform that almost half of the inmates in prisons are due to ordering the execution of the previously suspended imprisonment sentence. So half of the people who are in jail in Poland used to be because of the violation of the probation's rules. So now I will talk a little bit about the Polish legal context. So in Poland, if judges want to impose punishment of imprisonment, they should treat it as a punishment of the last resort. So the criminal code, which was enacted in 1997, was built taking into mind what happened during communist time in Poland. And the authors of the criminal code were hoping that there would be a decrease in the use of the deprivation of liberty in Poland, and they prepared a lot of different safeguards in the criminal code, which aims to ensure that the judges will not be imposing deprivation of liberty. So, for example, there was some symbolic change, that there was change in the order of the punishment. So in the communist time criminal code, the punishment were listed in that order, that it started with the deprivation of liberty, and in the new criminal code, it's starting with fine, and the deprivation of liberty was at the end. So it was supposed to consider by the judge to use not deprivation of liberty. So the imprisonment is a punishment of the last resort. So there is a lot of other provisions which are making ensure that the judges will consider whether there is a possibility of using some other penal measures than imprisonment. So we have three general in Poland, three probational instruments. So at the different level of criminal proceedings. So the first is before starting the criminal proceedings. So there is a conditional suspending of the criminal proceeding. So the next is a suspension of the punishment of deprivation of liberty. So after the imposing punishment, the judge could suspend the punishment. And the last probational instrument is the conditional release after prison. So, for example, if someone get 10 years in prison, he could go after 5 years conditionally. So this is the last probational instruments. Our studies were focused on that first two instruments. So conditional suspended criminal proceedings, and the suspended punishment of deprivation of liberty. And the reform which I was referring to in 2015 was focused on the suspended punishment of deprivation of liberty. So the issue of the discontinuance of the proceedings was not what's the case of that reform. So there is a provision which showing where under which condition the judges could suspend punishment of deprivation of liberty. I will be not focusing much on that, but we have to know that for our further discussion that there are two steps. So at the beginning, the judge should decide which punishment is deserved for that kind of crime that they is evaluating, and after that, the judge should consider whether that deserved punishment should be suspended or not. But in practice, it was not working that way. So the judges, when they were imposing punishment, they were thinking at the beginning that they will suspend punishment. So they were imposing punishment of deprivation of liberty in cases in which it was not deserved punishment. But they were not thinking that they are imposing the deprivation of liberty. They were thinking that they are imposing some suspended punishment, so only a threat of some harsher punishment. But as I showed before, almost half of inmates in Poland was due to ordering that suspended punishment of deprivation of liberty. So we asked judges in one study, and they proved that they admit that they were treating that punishment in that way. So the change of that reform in 2015 was not based on the logic of the criminal code, but the logic of the practice or the functioning of the criminal code. So there was a threat that if we will change that provisions, the judges will be more severe because there will be no possibility to suspend punishment. So there will be more unsuspended punishment of deprivation of liberty. So we did a research. So we were in the criminal code, in 14 district court, in 13 cities, in 9 out of 16 voivodeships in Poland. So these are big regions in Poland. We examined more than 3,000 cases in different parts of Poland. Our students who were going to that courts, and Daniel was one of them, have to ask for permission to see the criminal files and doing some notes after seeing that, and we collect more than 3,000 cases from all over the Poland. So we were studying 3 crimes: drunk driving, drug possessions, and theft. But theft was not good for our research because there was a lot of differentiation between the cases. So the most similar cases were drunk driving and drug possession, because usually it was no other variation. So it was easy to compare that kind of cases. And that kind of crimes were among most frequently committed in Poland. So if you are interested more about the methodology, so there is a lot, the huge report which was published in Polish, but also in the European Journal of Criminology. There is a text which we published, and there is a part of the methodology. You could look at it for more in-depth informations. So results, we wanted to focus on the probational instruments. So we checked whether the chances for the conditional discontinuance of the proceedings compared to other outcomes. And from that perspective, it changed drastically in different ways in case of 2 different crimes. So in case of drug possessions, after the reform, there was significantly lower the chances of discontinuance of proceedings, so at 38%. But in case of driving under influence, the chances of discontinuance was higher by 386%. So we could see how that practical reaction of that change of the provisions was. But in case of suspended punishment, which was the aim of that reform, the results were quite similar. So we noticed a drop by 75 and 76%. So here we could see the tables. And we could also add some more general data from this Ministry of Justice from Poland, and we could see that until 2015, almost 60–70% of punishment was deprivation of liberty, and out of them 80 to 90% were suspended. And after reform in 2016, deprivation of liberty was only 41%, and 62% of which were suspended. So we can see that the reform influenced the practice. Here is also the table. And now I will go to the discussion. So our study demonstrates that the statutory limitation of the possibility of using probation decreased the severity of the judgment. It could be paradoxical, but when I talk a little bit about what was the situation in Poland, it's not that unexpected. So the legislator's assumption regarding the reason for the overuse of probation was confirmed by judges' reaction to the legislative changes. And judges, in fact, decided to impose milder punishments, fines, and limitation of liberty. Our results also confirmed that the judges were too harsh before the reform, because they were imposing deprivation of punishment in case of the crimes which not deserve the deprivation of liberty. So other thing that we could add to our discussion, that if some other countries could learn something from our case, it should be noted that the sole presence of the widely sole presence of probational instruments in the legal systems will make the system that the imprisonment will not be overused. So sometimes maybe in the next step, it will cause that there will be more people in prison than before. So if someone is thinking that we will make widely available probational instruments and the judge will be using it in every situation that they want, it will solve our problem with overcrowded prisons. But it's not working. It could not work in that way. So the other thing that we could add that there could be a problem with effective probation. So maybe it is the case in Poland that the probational officers are not well paid. They have too many people who are there to take care of. So maybe this was the reason why there was a lot of violation of the probational rules. So the other general result from our studies, it showed that the hope that the normative change will easily transfer the legal systems could be too optimistic. So we could see that the reform was focused on the suspended punishment of deprivation of liberty, and in fact it caused a change in the way that the legislator was thinking about, but it also led to the huge change in the use of the previous probational instrument, which is the discontinuance of the proceedings, which changed drastically. So in one case dropped, in one case it was higher. So we were thinking why in the case of the drunk driving there was a increase of the use of the conditional suspension of the criminal proceedings, and we have some hypothesis that is connected with the penal measure of the prohibition from operating vehicles. So if someone is sentenced for drunk driving, it's almost obligatory in Poland that it will be they could not drive his or her car, and when the judges decide to suspend the proceedings, it could use that penal measure, but it's not obligatory, but it's facultatory. So, for example, if there is someone who is driving to work and needs driving license to make money for their living, so conditionally suspending proceedings could keep that job with him. So this also is showing that the judges taking into consideration the final result of imposing justice. So they are taking in consideration also how it influenced the situation of the person who is sentenced. So also, I think this is one of the last thing that I would like to mention here. So this is our research are also showing that there is a problem with lack of alternative punishment to imprisonment. So there is a discussion among philosophy of criminal law and among criminal lawyers that there is no effective way of punishing people which is compared to the imprisonment, and if there is no such alternatives, so judges are taking decision into their hands. So they, as was in Poland, adopt other criminal instruments to serve as alternative punishments to incarcerations. And as we showed that judges in Poland treated suspended deprivation of liberty as separate kind of punishment. So thank you for listening, and if you want to contact me, you could here have some details. So thank you.
Thank you so much, Kamil. Really interesting. Also look forward to hearing questions and comments about that talk. And now we're on to our final presenter, final presentation of this panel. So Mauricio Manchado from National University of Rosario, I hand over to you.
Okay, thank you very much, Liz. Thanks to Luis and Maximo and their teams for this event. I'm very glad to be here. I want to share screen. Okay. Well, okay, these presentations pretends to find answers, or if it's possible, to the question of what works on theories of desistance, question to think about dynamics of Latin American prisons, the case of the charged pavilions in the province of Santa Fe, Argentina. It's a kind of exercise when, and the main question is which are the potentialities and difficulties of the theories of desistance from crime to analyze the experience of incarceration in Latin America. So first of all, we will focus on narratives analysis of those who inhabit or inhabitate the evangelical Pentecostal religious device in prisons. I will explain what is the evangelical Pentecostal religious device in prisons. First of all, I want to say that one characteristic of the research, it's based on qualitative approach and in a fieldwork that was developed in the charged pavilion of the prison in the south of the province of Santa Fe, in prisons, in walls, and in the prison area of the evangelical church Santuario de Fe and its annexes out of the prisons, out of the wall. And we will focus for this reflection on the set of in-depth interviews carried out with the so-called little brother prisoners in charge pavilion of the Penitentiary Unit number 6 of Rosario, Santa Fe, Argentina, and with actors from the prison area of the church Santuario de Fe, assistant pastor and collaborator, an institution that has the administration of 3 church pavilions in that prison, but is also the largest evangelical congregation in the city of Rosario. In addition to this, we will incorporate data construct as a result of the participants' observations in worship service and evangelical campaigns carried out both within and outside the walls. theoretical reflections and empirical reference that are linked to a fieldwork developed for more than 7 years. Some characteristics of the penitentiary system in Santa Fe, Argentina. Actually, total incarcerated population is 6,320 people. Depends administratively on the government of the province of Santa Fe, and it's in the 4th place in terms of the number of incarcerated population in the country, after Buenos Aires, Córdoba, and Mendoza. It has 10 prisons, 8 for men and 2 for women, located in the south, center, and north of the provincial territory with dissimilar institutional profiles, ranging from penal colonies to maximum security prisons. Okay, when we talk about charge pavilions in prisons, we say that charge pavilions, as they are known in the prison argot, were created like a space of confinement organized by an external charge and managed under an internal structure in charge of the prisoners and under a series of very strict regulations. Charge pavilions are usually organized under a vertical, strong hierarchy, even if we can find different degrees in the internal rule enforcement across different units. Also, there are different levels of these hierarchies that correspond to position of power within the religious structure, mainly divided between 2 main figures, the servants and the chiefs. The servants are at the top of the pyramid and rule the entire unit. They must also guarantee the integrity of all their ship and ensure that the rules of conduct and coexistence are complete with and respect. If we focus in the living rules of the charge pavilions, 2 kinds arise. First at all, or the first ones cover security and cohabitation conducts, which are similar to those of the prison itself, including the no possession and use of drugs or weapons, for example. The second one, however, there is a second unique set of rules tied to morality, which seeks to pursue the precepts of the evangelical creed. Example of this second set of rules are prohibition from talking about previous offense and other vice, prohibition from masturbation, and the obligation to respect the hierarchy of the unit before making a complaint to prison staff, because it states that this type of request must first be communicated to the servants and other superiors in the hierarchy. When an infraction occurs, servants even have the power to punish these behaviors. Some elements to know about the history and the present of the charge pavilions. The evangelical Pentecostal religious device, EPRD, in Argentine prisons emerged after the democratic recovery in 1983, and in the province of Santa Fe case, we will work on this presentation and in these papers since 1986. At the end of the 90s and the beginning of 2000s, the confrontation of prisoners with the prison officer staff and of prisoners among themselves had already reached forms and quantities that demand to call attention to the house conditions. Faced with this stage, the EPRD came to propose a solution by exercising a knowledge whose final effect was the pacification of internal ties and a reconfiguration of prison power relations. These relationships between EPRD and the penitentiary system was defined by 3 different phases. The first, initial rejection by the institution and prisoners. The second one, a later period of relative acceptance. And the third, nowadays, coordination and cooperation between the two, between the charge or the charge pavilion and the penitentiary assistants of the staff. Today, the data referring to the number of charge pavilions in the main Santa Fe prisons show not only a relative acceptance, but also coordination, cooperation between both institutions. More than of the pavilions of the UEP number 1 ascribed to Religion Evangelica Pentecostal, 11 of 26. In UEP number 2, 6 pavilion and 1 floor of a total of 10 are defined as church. In UEP number 3, 2 of its 10 pavilions are established as religious space. In UEP number 6 has a total of 7 pavilions out of a total of 11 defined as church. And finally, the UEP number 16, 1 of its 4 pavilions, there were 2 until the last year, and finally up UEP number 11 with 7 of its 24 pavilions. Well, I want to propose some kind of exercise. So the question is how we manage to leak out the epistemological discussion that the theories of desistance engage with each other, to link rather about the cultural shifts that we must attempt to achieve a dissection of that great theoretical device, and put in dialogue some of these conceptual tools with the empirical reference of a research. We consider 3 theories for this exercise: the theory of control, where the weight is in the structure. Now, the process of the desistance of crime depends fundamentally on the social ties between members of a society and the institutions that operate as informal social controls, work, family, school, and community. The second one is the cognitive transformation that had the principal reference like Maruna, Maruna, Peggy Giordano. Here the weight is in the agent. No? For the theory of cognitive transformation, the origin of desistance is internal and refers to a personal reflection to the individual will to change. The third is the tension social support that say that this theory is a sort of synthesis, no? Where it's important the objective, no? It's important that the objective aid mechanisms exist as that it be perceived that this aid exists, no? The mix of the objective elements and the subjective elements. But there is a starting point that assimilates them. For the stop of the criminal practice to be possible, the construction of a dissenting narrative is essential. So we will focus in the narrative in these papers. I only want to mention this, that there is an interesting position that proposed Fergus McNeill and Margaret Schinkel about the primary, secondary, and tertiary types of desistance. I want to mention this brief quote when Fergus McNeill and Margaret Schinkel say that it's important to put it more clearly, desistance is a social and political process rather than a personal one. I want to mention because for me it's important to understand the phenomenon of pavilions. So in this exercise, I want to propose some results. In the narrative, we can distinguish, for example, the emergency of the divine manifestation and dying to pride as element of interaction between the breaking points and the hood for change. The breaking points respond to the structure, no? To the ties that I had mentioned before, and the hood for change, it's linked to the will, no? The hook for change that motorize the will to change. In the first place, we can affirm that despite working with data series of different orders and origin, the emergence of breaking point is recognized in the narrative under study, although they will not be linked to work, marriage, and military service in a generative framework, like says Samson and Love. They will be linked to E per D as an enabler and enhancer of a divine manifestation. Here a brief quote. Hernam in the UEP number 11. I had a meeting with God in a hand-to-hand, alone, locked in a place without food, beaten, abused, without water, without anything. And there God afflicted me, and I had a meeting with him. Informal social controls crystallize in an organization of civil society, the church, that generates the condition of possibility to continue and promote a meeting with God that happens in extreme situation of life in confinement. Here we can notice also the passage and the test of God. Divine manifestation like a passage of a past as a prisoner gadget, conflict, cachivache in a colloquial way in Argentina, and a present as a little brother prisoner, attached to the regulation, practice, discourse, and values defined by EPRT. A passage that is not homogeneous or linear, and where power relations are reconfigured under the native category of endurance, the test of God. Here a brief quote also on this. My wife now wants to separate. If you give place to that, saying, take your things and leave. But since I'm growing God, it's all from God because God puts you a test. It's to see your faith, to see if you really believe him because God is God who restores. So we can talk about a breaking point in singular, no breaking points in plural. The breaking point has a fragility and dematerialization of a spiritual apparition, the divine manifestation, with both inside and outside the walls is exposed to the temptation of devil. Show stability and marriage as keys to desistance that will be central variables in the narrative of the prisoners and mailing of the former prisoners, but they will appear subsidiarily linked to the role of religion. Here, the church should have a central role for the conservation of the roles built in church pavilions. And finally, two or three things I want to mention. Time to pray. The hook for change of Argentine prisons. The divine manifestation precedes the death to price, but they must be thought in permanent interaction. Dying to prime is the phrase that condenses the passage between a worldly way of life in the regular or common pavilions to the life of church pavilions. Dying to prime is to stop doing that we did, says a prisoner. The will also, I want to mention that in this narrative, the will is in the center. Yes, the will is in the center. ERD has hood for change based on an iron disciplinary scheme that articulates spiritual asceticism with prison regulation, mixing it with a redemption script, like Saint Maruna, that has at its center the ancient ability for transformation. But the question is, where is the focus of this will? No? Although we agree with the argument that hooks will need the influence of the actor to make a particular type of cognitive connection consistent with the idea of reflexivity, the difficulties of this approach to think about the dynamics of the ERD are given by the need to distinguish the set of four relations that unfold before, during, and after the arrival of a prisoner to church pavilions, the structural condition that places it at a space in contrast with the lethal violence of the rest of the prison, and therefore as a tactic for the management of confinement and the production of prison order, the set of positive and negative reciprocity established between the prisoners and between them with the penitentiary agents, in the modality of regulation of the conflicts that take place there, and in the working reconfiguration of the actor committed to the daily management of prison. So to conclude, light and shadow, finally we understand that the exaltation of individual agency proposed by the cognitive approach gives a significant prevalence to action in terms of personal will, and less in their political or community aspect. Thus, understanding the social practice of the little brother prisoners without regard that the plots of relationships, tension, and contradiction is, if not insufficient, at least partial when we try to analyze the narrative of change. I will pass this. So the question is, making good or stop being bad? No, the narrative of the prisoners who inhabit the ERD and the actors who participate in the outside prison ministry are constructed under the scheme of the self, where the past is no code with collective responsibilities, and where each emerge in highly diffuse terms, ambivalent, and with a high degree of non-person recognitions. Redefine the idea of Maruna, making good the narrative the men linked to the constructed process of stop being bad, from which the self-perception of waste becomes an useful subject once, thanks to the interference of an external force that calls for individual responsibility and collective blamelessness. Salvation is personal. The change depends on you. The things of God exist. It's only up to the individual will to decide if we take it or not. This is the discourse, the script, no? Therefore, the community is never ethical because it doesn't recognize in the self a link to will with the other, but rather as a reaffirmation of hypermoral community where everyone finds a higher purpose and satisfaction in fighting the good fight. The ultimate purpose is the reaffirmation of the self. This reaffirmation needs to operate for the moral and economic salvation of responsibility. So, I want to say to the conclusions that the hyper-T appears to us like a crystal where we can recognize the inscription of some of the conception views that the theories of desistance propose, and it remains to ask ourselves the question of whether other experience or device, educational, cultural work, that it's in a way very heterogeneous make up the prison kaleidoscope. It could also be object of study to understand, from the theories of desistance, the contemporary prison settings on the global south. Therefore, the question should not focus only on if works, but either on what works, where the analytical powers enrich the situate studies that are central to understanding the complex fabric of the prison order in today's prison. Thank you very much.
Thank you so much, Maurizio, and thank you all for being such good timekeepers. Excellent stuff. So thank you to all the speakers. So we've had Fazana, Ritu, Kamil and Maurizio, and now I invite Robert Werth from Rice University to comment and respond to these presentations.
Yes, thank you, Liz, and thank you for the invitation to discuss these papers. I found them all very interesting and thought-provoking. I think there's a lot here for us to think and talk about. But in the name of brevity, what I will do is I will share a few comments and then a few questions for each of the three papers individually. But then I have a few comments that I think relate to the entire panel and perhaps to the theme of the conference as well. All right, so first, the Paradoxes of Probation, Kamil, Joanna, and Daniel's paper. So your paper examines the impact of a criminal law reform that sought to reduce the overuse of probation with the hope that if judges cannot suspend a punishment via probation, they would instead turn to non-carceral punishments such as fines. And you found that this did indeed take place in the case of drug possession and drunk driving. Right? The reform led to fewer suspended sentences and more usage of non-prison, non-carceral punishments. Now, of course, there are very significant and very consequential differences between being incarcerated and being in the community on probation, or being in the community with a suspended sentence. At the same time, I like that your paper encourages us to think broadly about punishment, and it highlights the blurriness and the potential overlaps between some of these boundaries. For instance, over half of people in Poland who received a suspended punishment ended up with a decision to enforce that suspended punishment at some point. So broadly, you note that probational instruments can and do operate as a, albeit temporally delayed, gateway into prison. So this relates, of course, to larger discussions about whether probation really is an alternative to punishment that diverts people away or helps keep people away from the penal institutions, or does it operate as a net widener that enmeshes ever more people? Now, again, I'm not contending that imprisonment in a cell is the same as probation in the community, but conceptually, your paper highlights the importance of thinking about the penal or carceral continuum, or what Foucault calls the carceral archipelago. Or in the 1980s, people were talking about transcarceration. So I think it brings up these topics to consider very importantly. And your paper relates and contributes to ongoing discussions about alternatives to incarceration, including technological ones, such as electronic monitoring via cell phones or ankle bracelets, and concerns about e-carceration, electronic carceration, or other forms of incarcerative-like experiences, even if one is in the community. Now, a couple of questions I had is one, and related to this point, is you noted that since the reform in drug possession and driving under the influence cases, the chances of suspended deprivation of liberty declined by 75%, you say, compared to either fines or limitation of liberty. But what specifically is limitation of liberty in the Polish context, right? Is that something like probation? Is it day prison? Is it something else? Because similar to how nearly half of suspended punishments ultimately resulted in a person being sent to prison, does something similar happen for people sentenced to limitation of liberty? And then a second question is, you did not include cases involving women because, as you note, there were a low number of cases. But you also say because gender is a strong factor influencing sentence disparities. But might this actually be a reason to include women in your study? Now, yes, you would perhaps need to divide it into categories by gender, but I think it would be interesting to see what happened in the case of women. And then one last question is, you have data for only 2 of the 3 probation mechanisms. Why not the third one? Is it because it occurs both post-conviction and post-sentencing, and it doesn't entail the judge's decision, or is there another reason for not including that third instrument? Okay, so now the next paper, Nousheen and Khandaker. So exploring existing criminal justice and penal practices in Bangladesh. Love this paper. And conceptually, you're thinking about the impact of the colonial legacy of Bangladesh on one hand, and then you're also exploring the cultural, political, economic approach to punishment on the other. So how do we use both and think about, and I think more importantly, think with both to understand the current shape of punishment in Bangladesh? Now, I really like your opening section, the great review of the work on the political economy of punishment. I would say, however, that the discussion of the colonial history of punishment in Bangladesh, at least in the paper, is much shorter. And I wonder if this section could be expanded a little bit. I found myself wanting to know more. So in thinking about the colonial legacy and a cultural, political, economic approach, your discussion of both the prosecution and punishment of political dissidents really brought these two things together and showed the interweaving and the value of thinking with the cultural, political, economic approach to make sense of the post-colonial situation, clearly and powerfully. But you also did this with your mention of the deplorable living conditions and in the continued usage of capital punishment. But in the section that occurs sort of right after that, it's called Recognizing Cultural, Political, Economic Incentives Underlying Penal Practices. I found that section rather brief, and I found myself wanting to see a bit more just because that's so central to the arguments you're making. So you might want to consider expanding that discussion and linking it to some of the colonial history a little bit more clearly. And one question is, I would be curious to hear more about the politicization of the judiciary and your related point about the politicization of punishment and the process of justice itself, because this was clearly an important point to your paper, but it was one that was made rather briefly. And turning to the third paper, Mauricio's What Works on Theories of Desistance. So Mauricio's looking at both the potentials and the difficulties of these theories of desistance, which I appreciated that question. And let me first say, I really appreciate the data you have. Very, very good data. But in relation to the theories of desistance, great discussion, but one interesting thing to think about that I feel like you hint at, but you don't really pursue, is what are the assumptions that are built into theories of desistance? For instance, you talk about how individuals get framed as offenders and criminals in these theories and within the prison setting, but perhaps this line of thought might be a useful way to pursue, to consider some of the limitation, problems, or omissions of these theories. For instance, do not theories of desistance implicitly assume that future criminal acts are to be expected? Do they not rely on a vision of offenders as currently doomed to criminality if they don't change? So don't these theories assume a subject who is somehow defective, deficient, or lacking, and who needs to remake the self in some way? Or what Pasquino, thinking with Foucault, said is this is not homo economicus, this is homo criminalis in theories of desistance. Another thought is you're turning to the concept of turning points or breaking points to make sense of your data regarding the meeting with God, the divine manifestation. Fascinating discussion, but one thing I thought about is what if the concept of turning points doesn't properly account for the temporality at play in this process? What if rather than causal turning points are actually post festum, after the fact signposts that people use to make sense of a change that's already occurred, a change that they've already made? I don't know, and I'm not convinced of what I'm saying, and I'm not offering it as a critique, but just as a question to think about. Because in analyzing the social world, whether it's theorists doing it or us doing it as we're in our everyday lives, we provide narratives that temporally order and make sense of things. But what if our accounts are often temporally inaccurate? I really liked your discussion about Giordano's hooks in relation to your data, and I love that you say we need to account for state-based violence and the set of force relations that happen in the prison. And then you point to imprisoned individuals' actions, how we have to account for them or make sense of them as a tactic for the management of the experience of imprisonment and the production of social order. I loved that discussion. One comment or suggestion would be, I would have loved to see more about the dogmas and ideologies of the church group, the Pentecostals in particular, and the individuals involved. Now, you certainly had some about this. You talked about prosperity, and you talked about how they talk about the role of the devil, but I thought more, I was curious for more, but I think it also would aid your analysis. For instance, evangelical ideas about prosperity, about how Christians need to realize the prosperity, the overabundance that God provides for in this world. It's interesting to think about how that concept of prosperity would seem to reinforce an emphasis on individual responsibility, right? Because there's plenty to go around, so it's your responsibility to make sure you do it. One quick question is, do some people repurpose, avoid, or resist the redemption narrative? Do they push back on this idea that they need to redeem? Or is it that the people who might resist that don't get involved in the church pavilions in the first place? Okay, and then lastly, just for maybe 60 more seconds, some general comments for all papers and maybe for the conference, just to tie into the theme of how theories from and about the global north tend to saturate and overdetermine many of our conversations about punishment. So I think just thinking for a moment about what theory is and how we use it. And here I'm turning to the work of an anthropologist, Andrea Ballestero, and a piece she's written called Theory as Parallax and Provocation. So in this piece, she troubles the idea of using theory as a knowledge bank that we borrow from and apply to different contexts. Because doing that, using theory as a knowledge bank that can just easily move from one context to another, means that theory that can too easily glide over important differences across context and time periods. But also, as Ballestero notes, and here I'll quote, "Certainly, I am not suggesting one starts anew with every project. One can, however, intentionally bracket comfortable theoretical markers that seem to work too well and whose insights can be anticipated. This would be a tactic of inducing discomfort that might initially favor inquisitive untidiness over elegant parsimony." So she goes on, I'll be very brief. She goes on to talk about using theory not just after we have data to analyze and make sense of things, but before and during our collection of data to think through questions and using theory to incite us to change our perspective on what we're looking at and see things from new angles, as a parallax would do, but also using theory to pay attention to omissions. Just for instance, if we're using a Marxian theory or Bourdieu or what have you, what questions, issues and objects of studies might we not pay attention to when thinking this theory? What might get elided or overlooked using a theory? What comes to light and also what gets omitted? So I guess in short, in thinking about theories, what happens when we move away from theory as a knowledge bank to apply and instead move towards concept work that is localized, contextualized, and is based primarily in our data? The data at hand is what I'm proposing. With that, I will stop and thank you for all three of these very interesting papers.